Don't talk to him.
Court calls the case People versus Thomas Styron.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry?
I said I'm Thomas Styron, the living man, not Thomas Ulrich Styron, the entity you know me as, or as I'm in my papers. I'm here to address the matter.
All right, thank you. You wish to be represented by an...
The trial opens with the People versus Thomas Styron, but right from the start, things take an unexpected turn. Instead of quietly accepting the label of defendant, Styron boldly announces that he's a living man making a special appearance. It's a dramatic opening move, the kind that instantly tells everyone in the room he has no plans to follow the standard courtroom playbook. The judge is already stepping in, trying to steer the conversation back to basics just to figure out where everyone stands and get the hearing on track.
To address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen, if you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No. Not
today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes. Is it for the last two cases?
Yes.
Yeah, that one will swear in.
I am Tariq Maratari-Kade, the executor of the Tariq Maratari-Kade Living Trust and the registered owner of the Tariq Maratari-Kade Ex Relatione Kindaman Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and/or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand?
This is where the real resistance kicks in. Styron waves off the offer of a court-appointed lawyer, making it clear he intends to stand alone, representing himself propria persona. The judge, keeping a measured and professional tone, reminds him that even without legal counsel, he's still bound by Michigan's courtroom procedures and the established rules of evidence. But Styron isn't swayed. Instead, he pivots into a series of philosophical objections, treating state statutes as something foreign to him, something he refuses to accept as binding. In just a few minutes, it becomes clear every simple procedural matter is about to morph into a drawn-out debate over jurisdiction itself.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, You will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No.
So I do have.
Sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter.
The tension now moves squarely into the battleground of jurisdiction. In the very next case, the defendant takes a different route, claiming protection under both United Nations and U.S. declarations on Indigenous rights, arguing that the court has no legal authority over them. But the judge wastes no time dismantling the argument. He cuts off the theory before it can gain momentum, firmly stating that this courtroom is not situated on Indigenous land. His message is unmistakable. Inside these walls, there's no room for jurisdictional debates. The only interpretation that matters is the one coming from the bench.
On indigenous lands, subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers, agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation.
By now, the judge's patience is starting to wear thin. When the defendant keeps repeating that he doesn't understand the court's rules, the tone in the room changes. The judge delivers a sharp reality check. If you truly can't grasp the rules, that raises serious questions about whether you're even competent to face trial. Without hesitation, he orders a forensic competency evaluation and locks in a follow-up hearing date for July 25th, 2024. The underlying message couldn't be clearer. Refusing to follow the process won't make the case disappear. There's a structured legal path for handling those claims, and the court intends to use it.
I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this is this uh what are, excuse me, the what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
The judge then shifts gears, trying to lock in some cooperation for the upcoming evaluation. He asks plainly whether the defendant will attend willingly. But instead of giving a clear yes, the response comes loaded with qualifiers: under threat, duress, and coercion. The judge tries again, pushing for a simple answer, but every reply is wrapped in protest-style language that dodges the question. What follows feels less like a legal exchange and more like a slow-motion chess match, the judge aiming for straightforward moves, while the defendant insists on playing by an entirely different set of rules.
Anything from the people?
With the court, ask the people to prepare the order for the competition.
Yes, please prepare the order for this. Is that your address, sir?
Excuse me. That's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
The hearing closes with one final flash of friction, a dispute over a motion filed at the last minute. The judge points out that it's both late and, with the defendant's competency still under review, not something the court will address until after the evaluation is complete. Bond remains in place, the next hearing date is locked in, and the defendant is formally dismissed from the room. In the end, this wasn't just a legal proceeding, it was a contest of endurance and authority. And once again, the outcome made one truth crystal clear. No matter the argument, ultimate control of the courtroom rests firmly with the bench.